Broadside Books and Harper Audio present The Origins of Woke. Civil Rights Law, Corporate America, and the Triumph of Identity Politics. By Richard Hanania. Read by Timothy Andrés Pabon. A note before we begin. Don't forget to download the accompanying enhancement PDF from your audiobook provider. It contains tables, graphs, and charts, and will be referred to throughout as the enhancement. Introduction. This book is the product of more than a decade of research and thought about American politics and culture. It was only in the mid-2010s that the subject of wokeness came to dominate political discourse. The phenomenon seemed to start on college campuses. Within a few years it had migrated to other institutions. Those who critique what has happened to our institutions tend to think more of style than substance, pointing to instances of crying college girls demanding safe spaces, angry students yelling at their professors over microaggressions, and public debates litigating the definition of woman. From this perspective, when wokeness seeps into policy, it is usually in the context of debates about standardized tests and crime prevention. But it is common to see a self-identified liberal who has an aversion to the aesthetic components of wokeness, while accepting most of its policy agenda. Having followed these issues for years, I saw what was happening differently. To me, there was always something off about the mainstream liberal worldview when it came to issues of race and sex, and the role of government in preventing discrimination on certain protected grounds. Such goals, I thought, naturally resulted in misguided policies that were destructive in terms of personal freedom, economic growth, and even the mental health of much of the public. I had gone to law school and spent a summer interning at the Center for Individual Rights, a public interest firm that fought against overreaches in civil rights law. When I saw the rise of what most educated people call wokeness, it seemed to be only the long overdue cultural manifestation of assumptions and beliefs that have in many instances been deeply embedded in American law for over half a century. It is not that culture and aesthetics are unimportant. People can and do legitimately debate moral standards, the purpose of art, and the nature of justice. Wokeness as a cultural phenomenon has something to say about all those things, as does the backlash to it. But what I found strange about the anti-wokeness side of the debate was that its proponents seemed oblivious to the extent to which the beliefs and practices they disliked were mandated by law. No act of Congress or federal regulation technically requires one to express the belief that differences in income between men and women are due to sexism. But expressing the opposite view as a corporation can be extremely costly, and not just because of any potential public relations backlash. In the marketplace of ideas, the intellectual is free to be a conservative, liberal, libertarian, or anything else. The corporate executive, however, is only given one option. For so many public intellectuals and politicians to be anti-woke but indifferent to civil rights law struck me as similar to worrying about global warming but not bothering to know anything about energy policy. Of course, something changed in the mid-2010s, but when it comes to how major institutions in the country operate, the changes have mostly been superficial, at least relative to the magnitude of those that occurred decades before. Since at least the 1970s, major corporations have been forced to be highly conscious of race and sex and on the lookout for practices and behaviors that may have a disparate impact, which the law has considered a sign of discrimination. Since the 1980s, firms have been all but required to police the speech of their employees to prevent them from saying things that might...
Sample complete. Ready to continue?